we want to get this information to other people. Um, in April of this year, the Pump Act was passed, where we saw that women inside of the workforce will be able to have particular accommodations around lactation and breastfeeding. Following that, in June, we saw a really great win for pregnancy workers accommodations, where women who are pregnant, who may need small lifting accommodations or any form of accommodations for the wellness of their pregnancy, can now get those accommodations and request them from their employers. So we are so excited to bring on our partner, A Better Balance, who we have been working with on the federal and also the state level. We'll talk a little bit later about some of the work that we have been doing here in the state. Excited about the postpartum Medicaid expansion that has been going on. So we have been doing all of that work, and these are two wins that have happened for us. On the federal pipeline, protecting mothers, protecting families inside of the workforce. So I am going to turn it over to our special guest. So happy to have Cameron Dawson from A Better Balance, who is going to give us some education and answer a few questions about these new policies and how we can make sure that they are implemented correctly here in the state of Mississippi. So Cameron, I will yield to you. You can share your screen and I will also pin your video.
Thank you so much, Robin. And just want to confirm if everybody can see my screen okay with the PowerPoint. Before I get started, I'm seeing some yeses, and just want to say that these two pieces of laws could not have passed without the hard work and advocacy of the Mississippi Black Women's Roundtable, and collaborating with A Better Balance to make sure that we are sharing workers' experiences and really educating members of Congress and the public on what workers are experiencing. So I'm very proud to keep the collaboration going and really excited about how these two laws can really protect working mothers and birthing people in Mississippi. So this presentation is for informational purposes and is not considered legal advice. And, we are going to share some resources at the end, so that way you could share it with the mothers that you serve, with the families that you serve, and with your staff as well. And just to let you all know, I'm Cameron Dawson. I'm a senior staff attorney here at A Better Balance, and I work in Nashville, Tennessee in our Southern office, but we work across the South in all states to really ensure that workers don't have to choose between their health and their loved one's health and their paycheck. And so we do this by educating workers on their rights, but also advocating for different policies like pregnancy accommodations, paid sick time, paid family and medical leave, and flexible scheduling for workers and caregivers. And so Cassandra is going to share a little bit more about how we're continuing that work and how you all can get involved. And I just wanted to share, just a little bit about A Better Balance and our mission. So to begin, like Robin said, the Pregnant Workers Fairness Act was passed last year in December as part of the omnibus package and went into effect this June, on June 27th. And so after a decade of advocacy efforts, of sharing workers' experiences, of collaborating with national and state organizations, maternal health experts, and workers like you on this call, we were able to have our efforts rewarded and protect workers by having this legislation pass and go into effect. And this is a federal law that applies to employers with 15 or more employees, and it provides a clear right for covered employees to receive those reasonable accommodations or small changes in their work if they are pregnant and have a healthy pregnancy but need to avoid high risk factors in order to stay safe and healthy on the pregnancy, but also staying connected to the workforce. Now, this law provides for accommodations unless it would be an undue hardship or something that would be too expensive or too difficult on the business. And that is the same standard that we see in other discrimination laws when it comes to workers with disabilities. So a pregnant worker does not have to have a disability in order to be accommodated. They simply need to have a pregnancy related condition or a concern related to their childbirth or their lactation needs in order to request an accommodation as of June 27th. This law also does apply to applicants. So if someone is applying for a job and tells their employer that they are pregnant and would need accommodations, they cannot be discriminated against or refused that accommodation if they are hired. And it works in conjunction with the Pregnancy Discrimination Act, which is still in effect. This law simply provides for accommodations for pregnant workers. So there currently, is Title VII law and the Pregnant Workers Fairness Act that are federal laws that cover Mississippi workers. And so we're really excited to see this recent win in civil rights law for gender justice and racial justice, which has not been amended for decades. So this is really a big win that we could not have done without, the work of so many people on this call. And not only does it apply to private businesses, but it also applies to government employees. And so they do have a separate process, and I'll get a little bit into how the enforcement goes, but they do have a different process than some of the private businesses, but they are too covered by this law. So if a pregnant worker or someone who has recently returned from childbirth has a known condition that they need accommodations for, they are also covered by this new law. And it covers things like pregnancy while you're trying to get pregnant or while you are pregnant. If you need to have frequent or longer break periods, like a bathroom break or a resting break or a sitting break, then these are the types of accommodations you can request under this law. It also provides for access to water or snacks if you need to have a modification to your company's food or drink policy. A lot of pregnant workers may have low iron levels. They may be quickly dehydrated if they're working in harsh conditions outside, especially during this recent heat wave. And so, we're really trying to give them a legal right, which they now have in order to advocate for themselves and request those accommodations. And we've also, heard that a lot of workers may need a modified work schedule or a reduced schedule if they need to go to part-time or they need to, work certain hours like in the afternoon or the nighttime in order to avoid morning sickness. That can be a type of accommodation. But the goal is really to have an individualized assessment of each pregnancy of each pregnant worker and allow them the tools so that they can advocate for themselves with their employer. And their employer needs to provide these accommodations unless it would be too expensive or too difficult for their business to provide. And that's really based on the resources that that business has. So it's an individualized assessment. But these are just some examples of the types of accommodations. It doesn't mean that every pregnant worker is going to need accommodations, but if they do talk to their employer or their manager or HR and request these types of accommodations, they may be permitted to receive these. Some other commonly requested reasonable accommodations include limiting the amount of lifting that they may be doing, especially with weight restrictions like 20 pounds or 15 pounds. They can also request a temporary transfer to a position that might be free from hazardous chemicals or might be less strenuous on their body. And then, like I said earlier, for some workers who may be working as a cashier or in a fast food industry, they may request to have a chair or a small stool in their position or to be allowed to sit and take sitting breaks in the booth at their restaurant periodically to stay healthy. And these are all types of accommodations that can happen before and during pregnancy. But I also want to talk a little bit more about what types of accommodations can be provided for workers who are returning from childbirth. The Pregnant Workers Fairness Act can help with breaks as well as private space for breast milk and pumping. And this works in conjunction with another federal law called the Pump Act, which I'll talk about a little bit later today. And so some workers may not be covered under the Pump Act, but they may be covered under this PWFA law. So if they are working at a job with 15 or more employees, they are automatically covered under this PWFA law. So they are allowed to take breaks that are reasonable and as needed for their lactation or to express milk in at the workplace. And they're also provided a private space that's not a bathroom to pump at work. And this really needs to be a clean space that's free from intrusion or, interruption from other coworkers, just in case, they can't barge in while that worker is pumping or, invade their privacy there. But we've also seen some other types of accommodations that have been requested, like modifying their uniform. So if they are a police officer and wearing a bulletproof vest, there may be some request to have one that is more manageable or can fit over their belly, or it could be a temporary transfer to a different position that's for light duty. And feel free to put questions in the chat. We'll definitely have a time for y'all to ask me questions or to ask Cassandra and Robin questions. And I'll also share some resources too that has this information in our one pager for you to share or for you to take a look at. And along with the Family and Medical Leave Act, which many know as the FMLA, that provides 12 weeks of unpaid time off for workers who are caring for their own health or taking maternity leave or caring for a spouse or grandparent or child. The PWFA now provides additional time off to recover from childbirth, even if you are not qualified under the FMLA. So again, there are no time restrictions that are related to the FMLA with the PWFA. You do not have to work for your job for a year. Your job only needs to have 15 employees, for instance, and there is no full-time or part-time difference with being covered under the PWFA. As long as you have a business with 15 or more employees, no matter your status, you are covered and are now able to take this time off to recover from childbirth. It may not be paid, but it may run at the same time as any PTO, vacation leave, sick time, or short-term disability insurance that a job or health insurance may provide. So, we have seen though across this country, many folks, especially Black women, are not able to take a full 12 weeks off unpaid, as they are the primary breadwinners for their families. They're crucial income, that cannot be missed. And so, at least with this first step of providing job protected leave, we can ensure that some families can take off, the 6 to 8 weeks or even 12 weeks that they need to recover, especially from childbirth and other pregnancy related conditions. And it doesn't end here. We do need to still advocate for things like paid family and medical leave and paid sick time, so that we can ensure that all workers, no matter their zip code or their type of job, have access to those types of benefits and protections. And I do want to say, we just got finished with Black Maternal Mental Health Week last week. And, this PWFA law does also cover some postpartum conditions like postpartum depression and postpartum anxiety. And as we see that more often, Black women are experiencing these types of mental health conditions, as compared to other women, it's really important that workers can now use the PWFA to ask for time, ask for additional time off, ask for a modified schedule or other accommodations as they continue to address, their mental health needs. And lastly, I'll just say before, kind of moving on to the next slide, that other postpartum conditions like miscarriage are also covered under this law. So if, for instance, a worker may be experiencing a miscarriage or a pregnancy loss, they can also request reasonable accommodations under the law if they work for a business with 15 or more employees. And Like I said earlier, this does cover issues such as miscarriage, mastitis, and others. And so we have a free and confidential helpline, um, 1833 need ABB, where workers, if they have questions about the law, they can talk to an attorney for free, and they can have the answers that they need in order to talk to their employer, or if they find that their rights are being violated, they can learn about the next steps to enforcing those laws. And not only does the Pregnant Workers Fairness Act apply to those who are trying to become, who are pregnant or who have recently been pregnant, but it also applies to those who are trying to become pregnant. And so the goal is really to make a more equitable workplace where workers can talk to their bosses one on one and really be supported in those conversations and not fear retaliation or interference. So how does this all begin with this conversation, right? An employer can't necessarily pro offer an accommodation because they are being paternalistic, or maybe even because they have good intentions. An employer does need to wait and see if an employee requests an accommodation first before the interactive process can begin. But that's not to say that an employer can't notice certain things are happening with an employee and try to begin those conversations, but try to keep those conversations open-ended, as so that way you're not holding a bias against that pregnant worker, or thinking that that pregnant worker is not able to fulfill their duties as other workers can. But more typically, we do see that employees will talk to HR, talk to their manager about their need for an accommodation, but they may not use the magic words like Pregnant Workers Fairness Act or reasonable accommodation. They may ask for, a later schedule because they're feeling sick, or, they are needing extra bathroom breaks because they are needing to go to the bathroom more frequently because of their pregnancy. But once an employer sort of hears those concerns, that does kickstart the process for trying to find an accommodation that can fit the worker's needs. And sometimes the first accommodation request may not be the one that is settled upon, but the employer does need to provide an alternative accommodation that can still work and may not be leave. So some important language is to note in the new law is that it applies to a pregnant or a worker trying to get pregnant if they are not able to perform some of their main job duties, which can sometimes be referred to as an essential job function. So even if they are not able to perform some of those duties now, if they are able to perform those duties in the near future, and the accommodation is only needed for a temporary amount of time, an employer still needs to provide accommodation. They cannot simply refuse to do that accommodation or force that worker onto leave. They cannot, and we're still waiting on rules and regulations from the EEOC about, what that near future means or what that temporary amount of time means. But typically that means if, it's for the duration of their maternity leave, or, for a set amount of time, and those duties can be performed in the near future in a few months or even a few weeks, that typically meets that threshold, but we're still waiting to get more clarification on that. And even if a worker is not able to receive the accommodation request they desire, or an employer is trying to figure out the right accommodation, an employee cannot be punished during that time for needing, requesting, or using accommodations. So they can't receive absence points or attendance points while they are waiting for their job to find an accommodation for them. They can't have their hours cut, for example, or they can't be terminated, right? Is what we commonly see. That would be its own separate violation of the PWFA. And we really want to keep in mind that not every pregnant worker may even need an accommodation, but the goal is to know what their rights are as they progress through their pregnancy, and as they find that they may need an accommodation to stay healthy on the job. And so during that time, there are some additional employee protections that the law provides. And this has all been into effect about a month now. An employer cannot force an employee to take leave from work if a reasonable accommodation can be provided. So they need to go through that interactive process. They cannot force a worker to accept an accommodation that they choose not to accept. If, for instance, they don't have a known limitation, or if that accommodation is unnecessary to perform the essential job duties. And that comes from some experiences of workers where they are forced to change jobs and they never requested an accommodation in the first place, but their job may have assumed because they are pregnant that they no longer can work. Um, or, for example, they have requested a lifting restriction, but instead have gotten, for example, a modified equipment, right? That's unnecessary in order to perform certain job duties. So it really does need to be tailored to the medical needs of that worker. And lastly, I'll just say, an employer cannot deny certain opportunities like promotions because a worker needs an accommodation or uses one. And they cannot retaliate against an employee for trying to file or report a legal violation to the EEOC, which is the agency that oversees this law. Now, with this new protection in place, because this is a federal law, the Equal Employment Opportunity Commission is going to be the agency that workers are going to file reports to or file a complaint to. And under that agency, an employee has 180 days after the alleged discriminatory act to file a charge. And this can be the date that an accommodation was denied. This can be the date that their hours were suddenly cut short, or the date that they were terminated. But we want to generally tell workers that they need to file a complaint within those 180 days just to be safe and to preserve their federal rights. If they do, if they're not sure of the timeline, they can still file a charge with the EEOC. But if it is found to be outside of that 180 days window, the EEOC will give them what's called a right to sue letter, and deny that complaint. But then the worker has 90 days to file a claim in state court with an attorney. But unfortunately, Mississippi is one of the few states that does not have its own version of an anti-discrimination law on the books. And so, they may be able to really see what their options are with the EEOC first. And then federal government employees who are working in Mississippi, they do have their own process for filing a complaint. So the timeline is a little bit shorter, about 45 days after the alleged discriminatory act, and they go to an agency that's called the EEO. But they can also find that information on the EEOC's website to where they need to file a complaint. And we are expecting those rules and regulations from the EEOC soon. They do need to file, or they do need to complete the rulemaking process by the end of this year. And those rules will go on to explain some of the questions that we have left about the PWFA and give some guidance to employers. But if you are an employer and you're curious or concerned about some of the responsibilities you have, the EEOC does have some resources for employers, but also reviews the laws and the complaints for the employee and advocates and investigates on their behalf. And right now, it is still unclear whether or not employers are going to be allowed to ask employees to turn in a doctor's note with every request for reasonable accommodations. But if workers are asked to provide a note, we really do want to make sure that workers provide something that is specific. It details what type of accommodation you're asking for, and it indicates how long that accommodation is going to be needed. And we do have some sample letters and explainers for employees that I'll share in the chat afterwards. So this was a lot of information about the PWFA, but definitely want to see how much you all learned and take a couple seconds for a quick scenario. So I'll just add this one here. So on June 28th, Sarah works for a fulfillment center with 17 employees. She recently returned from maternity leave. Sarah still has issues lifting heavy items, which started during her pregnancy. What are some of the reasonable accommodations that you all think Sarah is entitled to? And feel free to put your answers in the chat. Okay, and feel free to put your answers in the chat under everyone so we could see. I know you all may be mini lawyers here, so we'll give a couple more seconds. What type of changes could she ask her employer for based on her issues with heavy lifting? All right, and let's see. So she could ask for a temporary lifting restriction or assistance with manual labor, a temporary transfer to a less strenuous position, right? No lifting of certain pounds. Thank you all for your great ideas. And again, the goal is to start a conversation, not simply to put workers like Sarah onto unpaid leave or to terminate them if they're not able to do the aspects of the job, but really to see, how can we help this worker for a certain period of time, maintain their health, heal, and stay on the job to provide for their family. So great job with that scenario. And I'll kind of pivot now to the other federal law that went into effect early in April, and just to kind of explain more about what that does to enhance some of the past laws we've had that protects nursing mothers. So this year, the PUMP Act, Providing Urgent Maternal Protections Act, went into effect, and it extended lactation protections to millions of workers. So for example, before, with the federal break time for nursing mothers law, only workers who were covered by overtime and hourly wage laws were covered. And this actually excluded workers who were teachers, nurses, and administrative staff, or met certain hourly or salaried positions. But now those requirements were taken away and edited. And so this extends those protections to teachers, nurses, farm workers, and more. It covers most employers, regardless of size. So there are some, so there's no limit to the amount of workers that are covered, but there are some special rules for workers that have less than 50 employees. If a job has less than 50 employees, there may be an undue hardship exception for providing the break time and space if it is too expensive or too difficult for them to provide. And then we are also seeing that certain motor coach and railway carrier employees will be covered later in 2025. So they are covered by this law, but the law is not in effect for certain workers to get access to that break time and space. But in 2025, that law will go into full effect for those types of workers. And unfortunately, airline flight crew are excluded under the PUMP Act. But like I said, they may still have protections under the Pregnant Workers Fairness Act if they do, in fact, need that break time and space. So again, we're seeing changes to these labor and employment laws that protect workers, but we're just trying to make sure that folks know about their rights when it comes to asking for break time or space to continue pumping. So under the federal law, employers are required to provide reasonable break time as needed for pumping for that worker's first 12 months after the child's birth. So there are some limits to the amount of break time they can receive. The Pregnant Workers Fairness Act does not have those time limits with the 1 year mark, but again, that break time and space is limited to if it would be an undue hardship. And that's based on the size, the resources, and other factors of the business. Pumping breaks are generally unpaid, but if, for example, a worker is forced to pump and work at the same time, then those breaks must be paid. Or if a worker is using their paid breaks that are already provided, then while they are pumping, they do need to be paid at the same rate. But for example, if a worker had a 10-minute paid break but was pumping for 20 minutes, 10 of those minutes may be unpaid, unless they were given, another paid break that they could join together in that 20-minute break. All right. So again, another scenario just to see how much you know with this new information. So Angela is a secretary who had a baby 6 months ago. Angela's manager told her that her pumping breaks are taking up too much time at work. So she will need to do paperwork during her breaks. Angela still has to clock out, though, for her pumping breaks. Is Angela's employer violating the Pump Act? And this is just a yes or a no uh, question. And thank you all for participating so much. Really appreciate it. Okay, I'm seeing yes, 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 exclamation point. Right? Okay, so, normal, everyone is correct who said yes. So great job, everybody. And just to give a little bit more of an explainer, normally, under the federal break time for nursing mothers law that was before December, the end of December of last year, Angela may have been previously excluded under the law because, she was a secretary. Now, this is if she was not overtime eligible. But now, because of the Pump Act, which went into effect the very start of this year, she would be covered, even though she is a secretary. Her employer may be violating the law, especially since she's now doing work during her pump breaks, and she needs to be compensated under the Pump Act for that time that she is spending working and pumping. So, and reasonable break time, it really does depend on what the worker's needs are. It depends on how far they have to walk to the lactation space, or, if they are using their office and having dividers. It depends on how much time they need to clean their materials and store the milk. That really does factor into how much of a break folks get. And sometimes workers will need 2 to 3 breaks a day or 1 to 2 breaks a day in order to keep their milk supply and their health, up to par. So that's why it is a broader standard, and it really is a case by case basis. But, the goal is to really work with the employee to see, how they can work together to make sure that they're able to express milk at work. And kind of moving towards the space aspect of things, there are some requirements that the federal law does require, and that is that the space must be shielded from view. So they can use a curtain, they can use a door, they can provide a separate room. It has to be free from intrusion, meaning that there needs to be a sign on the door or a lock, so that other coworkers cannot barge in or interrupt that space. And it cannot be a bathroom. There are some rules around, if there may be a lounge connected to the bathroom, or if there may be a separate space. And so it really does need to be sanitary and able to have those outlets and different things that really will support a lactating mother or a nursing mother. Now, this space doesn't have to be permanent. We've seen some spaces really create sort of hubs for nursing workers that are temporary spaces, but it does need to be available when needed. Some workers may have, or some workplaces may have issues with creating a whole new permanent space, but it does need to be a space for those workers who are nursing, so that they can be accommodated and their rights cannot be interfered with. So the new remedies that the Pump Act created that weren't in the previous law are now that, not only can a worker file a complaint with the federal Department of Labor, they can also file a lawsuit now. So before, there was just rules around going to the federal agency's wage and hour division and filing a complaint within 2 or 3 years of the discriminatory act. But now, workers can file a direct lawsuit. They don't have to file a complaint first, but if there are some certain rules around each type of violation that I'll go through kind of quickly. So for the lactation space violations, the first step, there are some steps that a worker needs to take before going to file a claim. So for one, they need to inform their employer that they are not providing the correct space, whether that not have a lock on the door or be free from intrusion, or be, insufficient in other ways. And they have to give their job 10 days to fix it. Now, this can be orally or written down, but they do have to wait those 10 days. Now, if the employer does not fix it within those 10 days, then the worker can sue. And so whether or not you go to a lawsuit or a complaint, they will investigate, whether or not those steps were taken, and try to see if there is either mediation involved or, other remedies that the worker is entitled to. And in other instances, a lawsuit can be filed right away. So that those rules only really go to the space questions or violations. But if it is a violation of not getting enough time, those reasonable break times, a worker can file a lawsuit right away. They don't need to notify their employer. If the employer has indicated it has no intention of providing private space, then the worker can also file right away. And if an employee has been fired for either requesting break time or space, then they can automatically file a lawsuit. They don't have to go back in and notify their employer. And so these kind of parameters are meant to protect workers, but the goal is, that if a worker does raise concerns to their manager or HR, they shouldn't be ignored. They should really, have those protections in place, so that way they're not retaliated against. And so I know that was a lot of information, and we will definitely get to some questions, but not all. So I want to send, you all some examples of our resources. We have a pregnant workers hub at our website, and I'll put the link in the chat where you can find examples of these laws and fact sheets, one pagers about that explain the information I just went over. And also we have a sample letter and explainer that workers can use if they do want to request an accommodation. And then we also have some information about the Pump Act on that website. And if you are interested in other laws like paid sick time or paid family and medical leave, or just what laws are available in the state of Mississippi, you can go to our worker rights hub, that's at abetterbalance.org, and find your state. And we do try to log in, based on category and scenario, whether you are caring for yourself or a loved one, or you're pregnant or returning to work after your pregnancy. You can find that information, but if you also just need one-on-one information, you can call our helpline at 1-833-NEED-ABB. And we do try to talk to workers one-on-one, to give them that information and that guidance. And so here's just more of our social media pages if you want to follow our work, and need to call for our free and confidential legal helpline. We do also provide information in Spanish, and we also provide resources in Spanish at that worker rights hub. So you can, also download some of the translated information. But just want to thank you all for your time and patience and grace, and, definitely happy to take some questions, and I'll stop sharing here.
Thank you so much for that, Cameron. So many words. Excited. I am grateful. I am thankful. All of the things, because that is work that will affect moms, in the workplace, and give some different accommodations to pregnant workers. So very excited about that. Thank you for giving such a detailed information about how we can protect women in Mississippi, and then also how we can continue to get these resources out and to continue to do the work. Are there any questions that anyone may have or need a deep dive into any of the things that Cameron discussed. And Felicia asked earlier if we would get these slides out to you, and we can do that. We will make sure that you have this information, especially since we have some facts and info for the EOC and how women can actually request those particular accommodations. If we do
So
not have,
I have a question,
go
Kathy
ahead,
Sykes.
go ahead. No,
So,
you're
so my
fine.
question is, women who choose to adopt, do they have the same coverage?
Great question, Kathy. So right now, this law is only covers for workers who are pregnant or returning from pregnancy or have a pregnancy-related condition. So it doesn't cover adoption, but there are some laws like the Family and Medical Leave Act that provides for the time off if you do need to go to foster placement appointments, or you need to care for a foster child, or a child that's currently being adopted. If that helps.
Thank you so much for that question. Excellent question. And we will also make note of that in our upcoming policy agendas to see what particular advances or accommodations we can make to families who are adopting children and bringing them into the family. Are there any more questions for myself or Cameron or Cassandra? Okay. Well, I'm going to let Cassandra come up and give our call to action and talk a little bit about this Mississippi work and how we have connected the dots, and then to tell you all what's next and how you can continue to help us with this work and to protect women.
Thank you, Robin. Robin don't know, but I'm gonna kick it back over to her as well, because we have a lot happening this week. Cameron, thank you as always for being a partner with Mississippi Black Women's Roundtable, but you also have been a partner with one of our partners on here, the Mississippi Low Income Child Care Initiative with Matt Williams. And so we just appreciate all of what you have done. Just a little bit of background, A Better Balance has really been a partner with us when it comes to, really healthy moms and strong babies, which is the campaign we've been using, particularly around pregnancy accommodations, paid leave, sick leave, and equal pay. In 20s, I can't remember what year it was, they actually helped us kill a really bad bill that was going into effect with equal pay, where there was going to be preemption in the cities, where they were going to have the cities. They introduced an amendment in our equal pay bill, I think in 2017, I believe it was, where they were going to have cities not be able to raise their wages and some of the other things too. And so Cameron and her team got to work, got a letter out, and just started calling our legislators, and they really helped us kill that bill. So we're really thankful for them. So we worked with them to actually try to get to introduce a pregnancy accommodation bill here in Mississippi. And some other bills too, but that was one of the main things that we have been pushing for years, to just do what they've done on the federal level, do it here. But now we have the federal law. And so our work continues, really is around the education. Now we want to work to make sure employers do this. So I believe one of the next things we'll do is have a convening just with employers, and we'll love to partner with you all to host a convening with them and bring Cameron back to educate them so that we can make sure that our workers are protected. We want you all to stay involved with us. Thank you for hanging in here with us. So one of the things that we want to be able to do, we want to, hold more of these workshops with you and your networks. So please, and Robin would drop her contact in there as well, and Cameron too. We want to be able to have you all let us come to your communities and host one of these, whether they're in person or via Zoom. We want to do that. The other thing is some of you all aren't connected to our Facebook and not on our constant contact list, or may not be getting our messages through text. And so we ask that you would text the word engage if you're not getting them, the word engage to 50457. We'll also put that in the chat as well. I'm actually going to turn this back over to Robin because we have a lot that we're doing this week. Actually, this week is Black Women's Equal Pay Week. Black Women's Equal Pay Day week. And so a couple of things are happening this week that we want you to know about and for you to be engaged. The Black Women's Equal Pay Day is actually falling in between a couple of different historic milestones. One has to do with it's 60 years since the passage of the Equal Pay Act. And then it's also 60 years since the March on Washington, which was about jobs, right? And wages. And so it's pretty historic that this is happening. And so this conversation that Cameron is doing reminds us of the work that is still yet to be done. And Monday, yesterday, is today Tuesday or Wednesday? Monday, I don't know what day. Well, Monday was the anniversary for when the federal minimum wage actually went into effect too. And so there's a lot here that we can really help remind us that this fight around work and wages continues. So I'm going to actually kick it back over to Robin, and Robin will share with you how to get involved in what we're doing for this week. Sheree, I see you. It's so good to see you, my sister. So good to see you. So Robin, I'm gonna actually kick it back over to you.
Thank you so much, Cassandra. I really appreciate that. So as she said, we are bridging the gap of these issues. I said yesterday on a call that we don't live single issue. There are no such thing, Black women have many issues that we need to be fighting for. And we wanted to make sure that this week, we actually turned it into a Black Women's Equal Pay Advocacy Week. It is a day. We are leading up into the observation, but we wanted to make sure that we weren't just talking about the wages, that we brought in all of the additional aspects for this work and what we are doing here at the City Black Women's Roundtable, and to kind of introduce everybody to our national partners. So I just dropped inside of the chat some of the additional things that we're doing this week. As Cassandra said, Black Women's Equal Pay Day is on Thursday. We have a wonderful toolkit that has been dropped in that you can use to share particular information on that day. We will do a national Twitter storm at 1:00 p.m. Central Time, 2:00 Eastern. So we are excited about that. And then Cassandra will be on a panel with the secretary. Is that correct, Ms. Cassandra? Yes.
And she's the chairman of the EEOC.
The chairman of the EEOC on tomorrow as well. So we're excited about that. We're excited about that conversation. And so we would like you all to join us, and that registration link is also inside the chat. Because we have some of our Mississippi and Jackson partners on, I am going to mention a wonderful project that we have coming up for restaurant owners in the city of Jackson, which is our High Roads Kitchen program. This program is where we are partnering with the city of Jackson and One Fair Wage to increase the tip wage for Black women, Black workers, tip workers, bartenders, and all of those people inside the city of Jackson, leading up into actually removing the minimum wage. But this is where we are starting and putting a foot in the ground. So we will start that process. Actually, it will launch tomorrow. The application will go live. So if you know of any restaurants, preferably in the BIPOC community, even if they are Black women, we would love to see Black women apply to this application. But we want to give $5,000 to about 10 restaurants to help them go through a training process and to help them increase their tip wage to $10. That is a huge win from $2.13 to $10 for our families that are working inside of the service industry. So wanted to lift that up. You can find that information on our website, and all of the additional things have been into the chat. So again, we are so excited for you all to join us. Thank you so much for spending this lunchtime with us and learning this great information. Cassandra, you can go ahead.
I just have one thing to add. In the toolkit, there are frames. Well, I'm not sure if it's in this one, but we will.
Get that to them.
It is in there. Okay.
Mhm.
There are frames that you can use for Black Women's Equal Pay Day for your social media post. Please use those and take a picture of yourself, Black women, Black Women's Equal Pay Day hashtag. There's some hashtags in there. Tag Mississippi Black Women's Roundtable in those. Like us on social media, Facebook. Like, we need you to stay in touch with us. Before we close, I do want to introduce my team to you all. Robin took it and didn't introduce who she was, but she is new to the team, but not new to this space and to this work. She's actually been with us for a very long time in our coalition work. But Robin Jackson, she is our policy advocacy coordinator. Robin, thank you. And then Alicia Natterville, I'm gonna bring her on camera and just for her just to say a few words. But Alicia, she actually leads our policy work during the legislative session. And so I'm just gonna bring her on the camera for a minute just to introduce herself to you all and to just say a few words.
Hello, everybody. It's nice to meet everybody. As Cassandra said, I'm the policy consultant with the Roundtable, and I am tasked with developing or helping the Roundtable develop its legislative agenda and working with outside lobbyists to move that agenda through the session. Of course, I don't do that by myself. Of course, the Roundtable does not do that in unison. So we are still in the process of developing our legislative agenda. Right now, we are in the process of tracking implementation of our last year's agenda, which our top tier item was postpartum. So we are currently in the process of trying to track the implementation of that. We're getting ready to send out public records requests to the Division of Medicaid to determine how people are being transitioned from 3 months of postpartum to 12 months. So we'll be in touch with that. And we're also in the process of developing our 2024 legislative agenda, and we'll be in touch with that agenda soon and throughout the session with action items and also updates on the bills that we are monitoring and tracking. Thank you.
Thank you, Alicia. And I'll bring on camera Melissa Overton, just so you know who a little bit of my team is. She may not be able to get on, but Melissa Overton runs hey, there she is. Wave to the people. So Melissa, she runs our community outreach and our rapid response work in community, and does an amazing job with just being on the ground, touching on people. And then we have Zakia Thagger. Zakia's been with us for a long time. She started as an intern. Her title's still intern, but she really is not an intern. She really helps do a lot in filling the gaps, but she is a master's level student at Jackson State in public policy health, something like that. I may not have gotten it right, but just want to introduce you to our team and just say thank you all so much. So I'll turn it back over to you, Robin.
Thank you so much for that, Ms. Cassandra. We really appreciate that. It's a wonderful thing to have leadership that makes sure that the team is recognized in spaces. So we appreciate you for that. Again, if there are any additional questions that anyone may have, feel free to reach out to us. I did put my information in the chat, and I believe that Cameron also put her information in the chat. Like Cassandra said, we would love to do these more often. We want to get this information to your communities. So if you have an opportunity for us to come and speak or need to, we can do this virtually. Just let us know and we will be sure to do that. So thank you so much for joining us, and you all will hear from us soon. Have a great day.
Thanks, everybody.
Thank you.